Good afternoon. Happy Sunday. Chili was going on and on in his live stream that I've done two live streams on now. But he was going on and on in that about how judges are appointed for life and that somehow a travesty that makes it a monarchy. I'm not entirely sure how that works. Uh, Judges aren't immune to discipline up to and including being removed from office. We're looking at how that happens with federal judges. I'm sure states will have different mechanisms because each state can deal with its own judiciary however it chooses. But this is how the federal government deals with it. This is 28 USC. This is chapter 15, starting at section 351. You can make there was an act. It's called like the Judicial Discipline and Disability Act or something along those lines. I forget the actual name of it. Doesn't really matter as far as I'm concerned. But what that does is allows you to file a complaint, and you can file a complaint if you think that your judge is prejudiced, is acting with prejudice, and or if you think that the judge is mentally or physically disabled to the point where that judge cannot effectively act as a judge in your case. And what happens is the complaint goes to the chief judge of the circuit chief judge. And then what happens is that judge, the chief judge of the circuit, will review it. And he won't do a lot of research into it. It's a limited inquiry, but he will do a little bit of inquiry into it just to see if it's a valid complaint or if it has the indicia of being a valid complaint. And so what he could do at this point, he has two real things that he could do. He could dismiss the complaint. This is normally where complaints end. A lot of times people like Chili think that just because a judge rules against you, that means the judge is prejudiced because there's just no way a judge could ever think that I'm wrong and the other guy's right. But sometimes you're wrong and the other guy's right. So normally this is where it ends. And the next thing he could do if he or if he thinks that appropriate corrective action has been taken, then that could end it there. But then if that doesn't do it, then the next step is it gets referred back for review to a panel, and he has to form a special commission. The next step is he forms a special committee. And then so the special committee would then do they'd look into it, and they can actually conduct an investigation. And once they've conducted an investigation, they file the report with the Judicial Council, and it will present the findings and recommendations. And then the Judicial Council, this is where you can really get some action. You'd start getting some action. The Judicial Council has some possibilities. They can dismiss the complaint. They can conduct additional investigation, and they can take some actions. And they're somewhat limited in the actions that they can take. So they can reprimand or censure the judge. Great, the judge would still be a judge, right? For Article 3 judges, they can certify the disability. Because remember, Article 3 judges are appointed for life during good behavior. And that's important. It's during good behavior. So they can certify the judge is disabled, or they can request that the judge voluntarily retire. For magistrate judges, they can take action, more direct action. They can actually remove magistrate judges. As far as like the limitations, they can't order a Article 3 judge to be removed. And any removal of the magistrate judge or bankruptcy judge has to comply with other sections that we're not going to deal with. If the Article 3 judge, if they think the judge has to be removed, then they refer it up to the Judicial Conference. And the Judicial Conference would then take a look at it and see if impeachment is warranted. And impeachment could be warranted for a variety of reasons. One of the reasons is a felony conviction. If the judge had a felony conviction and was no longer. There was a final decision that he's exhausted the appeals and everything like that. Um, well, it's impeachment o'clock. So also, if they believe that the judge was prejudiced or otherwise conduct unbecoming, they could then send it up to the House of Representatives for impeachment. What the House of Representatives would do at that point is they would look at the individual charges and they would vote on whether or not to send those charges to the Senate. When it gets to the Senate, they would conduct essentially a trial in the Senate, and the Senate would then vote on whether or not to convict. There have been 15 judges. I don't remember a lot of these. I do remember Thomas Porcius. I don't remember Samuel Kent. Apparently, it was about the same time. Oh, because he didn't go through. Thomas Porcius, though, he did the full shebang. He was taking bribes. He was taking bribes, and so he went through a bankruptcy. He filed bankruptcy, and that got everybody to start looking at his all the money. And what he was doing is he was letting lawyers bribe him. Not a common occurrence. Remember, there have been only 15 judges that have been impeached. So this is not a common occurrence. 15 judges since 1803 have been impeached. And not all of them have been successfully impeached, i.e., removed from office. But Thomas Porcius was. So they investigated him. The House, almost unanimously, for the engaged in a pattern that is incompatible with the trust and confidence placed in him as a federal judge, passed the House 412-0. Engaged in a longstanding pattern of corrupt conduct, 410-0. Knowing and intentionally making false statements under penalty of perjury related to his bankruptcy filing and violating a bankruptcy order, passed the House 416-0. And knowingly making false statements about his past to both the U.S. Senate and the FBI in order to obtain the office of the United States District Court Judge, 423-0. Then it went to the trial in front of the full Senate, and the Senate actually voted to convict him, 96-0 for the incompatible with trust and confidence, 69-27 pattern of corrupt conduct, 88-8 on the knowing and intentionally making false statements related to his personal bankruptcy filing, and then 96 or 90-6, 92-6, knowingly making false statements to the U.S. Senate and the FBI. And then this vote is to disqualify him from forever withholding any office of honor, trust, or profit under the United States, 92-0. He gave up his law license in lieu of facing discipline. So he basically, he didn't really have a lot of choice. If he didn't just voluntarily give up his law license, then the Louisiana State Bar would have taken his law license from him and probably fined him and all sorts of other fun stuff. So, he gave it up. He's never going to practice law again, although he's probably a million years old by now. Oh, he's dead. He died in 2021 at the age of 74. So it does happen. That's how it happens. Just because they're appointed for life, they're appointed for life for good conduct. So there is a mechanism to remove them if they are, in fact, engaging in crimes and misdemeanors and conduct unbecoming, or like corruption, taking bribes, things like that, lying under oath. So there you go. It's only an issue for Chile because Chile is one of these people who thinks that if a judge rules against him, the judge must therefore be corrupt or prejudiced or something. Anyway, that's it. Thanks for watching. Have a great day.